Good afternoon. My name is Tim Doyle. I'm a senior advisor here at the Bipartisan Policy Center. For those that have been following BPC over the past couple of years, they know that today's discussion is one we have been anticipating since last year. Securities and Exchange Commission, the SEC, proposed their climate-related risk disclosure rule on March 21st, just a few weeks ago. Today, we are going to talk about what's in the rule, its rationale, and some concerns. I can't think of anyone better to have this conversation with than Troy Paredes. Thank you for being here, Troy.
Great to be here.
For those that don't know, Troy is a former SEC commissioner. He was a commissioner under President George W. Bush from 2008 to 2013. He's a graduate of UC Berkeley and Yale Law School, founder of Paredes Strategies. Troy, I think the last time we were together in person, at least, was back in 2019 at an event on corporate governance of some issue, if I can recall correctly.
I think that's right. I can't believe it's been that long. Doesn't quite feel like that long. On the other hand, a lot's happened since 2019. Turns out
it has. Nice to see you again.
Nice to see you.
We have Troy and I have been talking about this rule for a bit now. We realize that there's just a ton of information that is packed into this rule, both textually as well as the rationale for it, and then some concerns, as I mentioned. So we're going to try to keep this as high level as possible. But I think because of the broad nature of the audience, I do want to do a level set on the SEC. And of course, Troy, I can't think of anyone better than for you to help me on that. And Troy, I'm wondering, obviously the SEC, for those that know, was created as a result back of the 1929 stock market crash as a response to a number of people, obviously, that lost their investments. And as a result of that, this independent agency was created with this tripartite mission. I was wondering if you could just briefly describe what that mission was, or is, I should say.
Yeah, was and is. So the way it gets articulated by folks is investor protection, fair, orderly, and efficient markets, and facilitating capital formation. And while they are oftentimes identified as three separate parts to the SEC's mission, the fact of the matter is they intersect and they support one another in a whole host of respects, but there may be instances where they can come into some tension, and maybe you have to figure out which way you're going to lean this way or the other. When you think about what that means in more practical terms, one thing you say, the tripartite mission and what it is, and you say, well, okay, how does the agency go about meeting that mission? How does it go about fulfilling that obligation? And that itself would take us the rest of the day to plow through. But at its core, I think there's widespread agreement that the SEC's core operating tool is disclosure, is to get information in the hands of investors so that investors can make better informed decisions about how to allocate their capital. And the focus there in particular has been historically on material information, which is something I'm sure we'll get into. What isn't materiality, how to think about materiality. But there are two basic premises even beyond that that I do think are important generally to what the SEC does, and this rule making is no exception. And that is a recognition, and we go back to the founding of the SEC, a recognition that it's better to allow the marketplace to decide how capital is going to be allocated as compared to the government making the decisions around capital allocation. And again, the means to facilitate that is to give information to investors so they can make those decisions in an informed way, but still in lieu of the government making those decisions. And number two, a recognition of the potential and the power, quite frankly, the practical power of so-called market discipline and private ordering. And that is to say, once again, through the power of disclosure, allow the marketplace to bring discipline to bear, so to speak, and for the marketplace to come up with solutions that in some instances may be preferable to what the government might otherwise impose. So as with everything, to put it in terms of extremes, it's all this or all that, would be to overstate in either direction. But just in terms of some of the flavor as to what the SEC has been about since its inception, I hope that's helpful.
Yeah, I think so. And what we've heard about not only this particular rule, but I feel like this is an ongoing debate, depending on of kind of who's in the chairmanship at the SEC, is whether this disclosure you're talking about is a principles-based one or a prescriptive-based one. And realizing that my understanding is, and I want to make sure I have this right, is that traditionally it's a principle-based one, as you said, based on materiality, and that gives the companies the ability within a framework to disclose information. However, there, of course, are certain circumstances, for instance, the Enron case and others, where the accounting disaster happened. And then we had as a result, a legislative response in Sarbanes-Oxley in, I think, 2002. And then again, of course, Dodd-Frank in 2010, which was to kind of respond to the financial crisis. In both of those pieces of legislation, Congress directed the SEC to be very specific about what they were going to disclose, or very prescriptive about what they were going to disclose of companies. I was wondering if you could just briefly talk about the differences between the principles-based versus the prescriptive-based.
Yeah, a principles-based approach as a practical matter would identify a particular principle that would drive the determination as to what does or doesn't have to be disclosed. Certainly materiality is part of that. But it could be a disclosure which says, disclose the material risks that are going to have an impact on the financial and operating performance of the business. And then you allow the board of management to have some measure of discretion to evaluate and make a determination as to what those key risks are that ought to be disclosed. And take that on the one hand as a way to think about a principles-based approach, as compared to the other end of the spectrum, something more rules-based, something more prescriptive, if you will. Could be you shall disclose the following things, and you shall disclose them under the following circumstances, and you shall disclose them in the following ways. That would, of course, be much more rules-based and prescriptive in nature. Now, the reality is that everything's always a bit of a blend, and that where you draw the demarcation between something you would call principles-based versus rules-based, one could have that debate and go around and around. Though the labels can help to kind of guide one's overall assessment and thinking. But one other quick note to add to it, Tim, is the following. Even things that start out as principles-based, sometimes over the years and the decades become in practice a bit more rules-like, through interpretation, through guidance, through understanding and interpretation. And so again, the demarcation sometimes can be a bit blurry. But I do think it comes down as a practical matter to, in some respects, how much discretion does the board, does the management team have in fashioning the disclosures versus how much of that is going to be dictated more prescriptively by the regulator.
And in fact, in this particular case, there are, and we'll talk about this in a minute, but there are existing regulations with regard to climate-related risk, and that were on the books. But then you had your 2010 guidance that came out and helped explain what those climate-related risks, or explain how they should be disclosed. I'm assuming that's kind of what you're referring to when you mentioned guidance changes that what maybe originally was considered the rule.
Yeah, it's a perfect example, and one that's perfect, particularly given what we're talking about today, where the SEC, for example, has had risk factor disclosure requirements for companies for a long time. In essence, disclose the material risks that would affect the business. You can understand why that would be important to investors making decisions. And another example where folks have pointed to where climate risk in particular could be accommodated is in so-called MD&A, management's discussion and analysis of financial results and operations, where you're supposed to talk about, through the eyes of management, the kind of prospects for the business and trends and uncertainties and the like, which could reflect impacts from climate. But when you look at those particular disclosure requirements under so-called regulation SK, while there's a lot to them, you still see at core a flexibility that the board has to be able to make, the company has to be able to make those determinations as to what rises to the level of needing to be disclosed. And as you said, the 2010 guidance is something that says, look, within the construct of the then existing disclosure requirements, the SEC said, here are some things we think you need to be disclosing as you prepare these disclosures that are already on the books, which is a different approach than what we've seen the commission propose, which is to say, sure, you have certain existing disclosure requirements that may require you to make climate-related disclosures. But in addition to that, risk factors, MD&A, et cetera, we're going to propose the following. And that's what they came out with 2.5 weeks ago.
Right. And so one of the issues that we hear about, or at least that has been expressed via op-eds and various papers and trade associations, et cetera, is the legislative authority for this rule. The SEC has claimed, has indicated that it is the rule itself is necessary or appropriate in the public interest for the protection of investors, and I feel like you hear that quite a bit, citing that tripartite mission that we mentioned, but specifically, SEC Chair Gary Gensler has indicated that the investors are demanding this. They're demanding more consistent, comparable, and reliable information, and that the existing disclosures that we just mentioned don't protect investors. And then even on top of that is a broader argument that, well, and we can talk about it in a minute, citing FSOC and other positions taken by the current administration that regarding the systemic risk regarding climate change. All of those kind of come together as an explanation for this. On the other side of it, we've heard that people are saying climate policy is the purview of Congress, and that the SEC is going beyond. This is they're beyond their authorizing legislation from Congress. And I think even Commissioner Hester Peirce and former Chair Jay Clayton have, in a recent op-ed, indicated that in this particular case, that this is pushing well beyond their authority. Where are we with that? I mean, Troy, I mean, obviously the Securities Act of 33 and 34, as we referenced more or less before, as a result of the stock market crash, we have these other legislative responses to various crises, financial crisis. Where are we on the authority for this rule?
I suppose we're going to find out, to be honest, not to be glib, but to be honest, where things are. I have no doubt that will be a subject of discussion going forward as this rulemaking proceeds throughout the notice and comment process. We certainly saw it in Commissioner Peirce's dissent, raising the question as to whether or not the SEC has the authority, perhaps going beyond from her perspective, raising the question and forming a view as to whether or not the SEC has the authority to undertake this particular rulemaking. Some of the questions that will come up partly relate to what you were saying on the question of materiality. Even that has its nuances to it in terms of the interplay between materiality on the one hand and the SEC's authority on the other. The reference to public interest is of interest in the following sense. What is the scope? And I think, Tim, this gets to the heart of what you're getting at. And I don't have the answer. I can just tee up the question. What is the scope of the SEC's authority in light of the reference to public interest? So to put that a little bit differently, to what extent is the SEC's authority to advance the public interest subject to, if you will, its tripartite mission, subject to, if you will, the effort and the goal of putting in material information into investors' hands so that they can make informed decisions when they're searching for a financial return? To what extent does the SEC's authority go beyond its traditional mission, or to what extent does the SEC's authority go beyond getting material information into the hands of investors so again they can make an informed decision focusing on financial returns? I would be loath to turn our discussion today into an in-depth discussion about administrative law or even constitutional law. But I think to recognize that will be a part of the rulemaking process and of the notice and comment process is important. To put it a little bit differently, on the one hand, a lot of the focus often when it comes to SEC rulemakings and other agencies is on the Administrative Procedure Act and cost-benefit analysis and economic analysis and the like. From time to time, the authority question presents itself. But what I think is just an interesting quick note to make is that an agency, and I'm just going to speak more generally now, an agency can have a sound rulemaking process, but still not have the authority to do what it did. And likewise, an agency can have the authority to do what it did, but not have a sound rulemaking process. And so it will be something I think that will get, as I said, a lot of attention as this process plays out. And the substantiation for that assertion is, I think, again, one need look no further than the points that were made by Commissioner Peirce in her dissent.
Right. Well, I know that talking to a number of people about this rule, the response I've gotten, especially from the one that this is not the purview of the SEC, that this is a congressional, this is really Congress. Congress needs to set climate policy, and then as a result, the SEC needs to implement. But I've had a lot of people say, well, what if Congress doesn't act? Doesn't the SEC have an obligation to ensure that investors are protected by getting this information because of how important climate-related risks are? And to I guess to parrot you, I guess we'll see and we'll find out. It'll be an interesting one.
Yeah, and I think there's a little bit of kind of unpacking that, which is this distinction, and I don't want to overstate the distinction, but the distinction between, on the one hand, climate policy versus, on the other hand, what's the information investors need to make an informed decision about how to allocate their capital. And in saying I don't want to overstate the distinction, there may be points of intersection. In some sense, that's what I think the commission would say in terms of the at-core justification for the proposal. But those are different objectives. The objective of addressing climate risk as such is a different objective than putting material information in the hands of investors so they can make informed decisions when it comes to how they allocate their capital and how they vote. And I think a question, Tim, to your point, as you were saying, that folks have raised is, as between those two, what is the limits or breadth of the SEC's role? And then what does that mean in terms of how to evaluate the proposal? And there certainly are different views that folks have come to as to how to answer those two questions.
Right. And before I forget and don't get in trouble internally, to everyone watching, if you could submit your questions using the live chat on YouTube or Facebook, or on Twitter, use hashtag BPC Live. Appreciate it. So I had some questions regarding, do a level set on executive action. I also briefly mention, for those that don't know, President Biden in January of 2021, an executive order establishing a whole of government approach to climate. In May of 2021, he had an executive order dealing with climate-related financial risk that I think you could make a pretty good argument that this rule, there's at least some connection with, especially given the language that is in that executive order, talking about a consistent, clear, comparable, and accurate disclosure of climate financial risk. As well as I mentioned the Financial Stability Oversight Council and their finding that climate risk is a systemic, the climate-related issues are a systemic risk to the economy. So we'll move through here because we have so much to cover, but those are, I think, worth mentioning to people to get their level set on where the climate broader issue is. And then, of course, to mention, and this goes into the actual rule, so we can move on to, is that it's worth mentioning that last March 15th, then acting Commissioner Lee submitted a request for public comment or a request for public input on climate-related risks. And I bring that up mainly because when you read through this rule, for those lucky enough that have been able to have the time and effort to do so, they reference these comments throughout. And I think that it's very noteworthy to do that, especially going forward as people are considering commenting on this particular rule. The SEC does read those, categorizes them, and I think in that particular case, they indicated there are like 600 unique comments from that request. So for those thinking about submitting comments, really you should. So I'll move on. Logistics of the rule. A lot of people have asked, and many know, but just so for those that don't know, comment period, speaking of those comment periods, is May 20th. And I did want to bring that issue up, Troy, with you, because there have been some concerns that the comment period in general, not particularly just this rule, but in general, have been shorter as of late, or under this particular SEC. However, some of my response to that is, well, they did in fact already request public comment once before, even though it was a request for public input. Can you please address that? Because I know there's people that are really concerned with that, and I think the U.S. Chamber and some others have submitted comments specifically regarding the shortened comment period.
So what the concern is rooted, well, part of the concern that folks have expressed in terms of the shorter comment periods than might have been expected or preferred is it's just difficult. All right, I'm just make it as simple as can be. It is difficult to crunch through a 500-page release and to really, in a hopefully thoughtful way that's going to assist the regulator to develop all your thoughts, perspectives, suggestions, likes, don't likes, kind of don't like, what would be better, right? That is just a time consuming exercise. And it's not just the exercise of writing the comment letter, it's getting input from a whole host of different perspectives within an organization to bring all of those to bear, particularly in the context of a rulemaking like this, where it's not just about, if you will, financial regulation. It's not just about finance or our capital markets or even corporate governance. There are a lot of technical aspects to it because of the nature of the subject matter, that is to say, climate. And a lot of things that companies have, in some instances, very little, if any, experience doing by way of some of the disclosures and collecting the data and processes and controls and the like. And then even those instances where they have some experience, they don't necessarily have the experience doing this. And so just thinking through the mechanics of how you would comply. So when you think about the quality, if you will, of the soundness, for maybe a lack of a better way to put it, of the notice and comment process serving its intended value, the question is with more condensed comment periods, do we as a whole, and the regulator specifically, get as much out of that notice and comment process as is possible? That's the concern, and then how that then ultimately has a bearing on final decisions at the regulator. I think from the SEC's perspective, as you said, the view is, look, this is not a new issue. This issue has been discussed a lot. There have been advanced requests for information from then acting chair Lee. There was a lot of engagement and participation in that. So the marketplace, if you will, interested parties are already farther along in the process than might otherwise be the case. Now, let me just give a quick response to on the one hand, on the other, is perhaps one might say, fair enough. On the other hand, responding to a set of questions that were very thoughtful questions by acting chair Lee in advance of a proposal is not the same as responding to a 500-page proposing release. That those are different exercises. And so therefore, whatever the engagement and opportunity to offer a perspective in advance of the proposal is not in and of itself a reason for a more condensed comment period than might otherwise, in the eyes of some, be necessitated. So that's a bit of the back and forth. What's the practical takeaway? May 20, and we're already a couple of weeks into that. And so to your point about comment letters matter, I can assure you comment letters matter. They're taken very, very seriously. And so for those who are inclined to, participate in the process, the strong suggestion would be you don't got a lot of time left. There's a lot here to crunch through and to think through, and to make the effort if you're so inclined to weigh in.
Yeah, to that point, I'm going to try to get pushed through because we still have a lot to cover, and I keep slowing down. Maybe some more mundane things, but one thing I do want to mention is, as proposed in the rule, the effective date, which for those issuers, companies that are listening, effective date is December 20, and depending on the size of your company and how you're structured, this will require collecting this data starting in 2023, minus scope 3, and then in 2024, reporting with limited assurances, in 2026 with reasonable assurances, all of which is described better in the rule. So I don't want to spend too much time on this now. I do want to get on, but it is worth mentioning that the rule sets out a fairly rigorous schedule depending on your company type. Troy, I want to move on. One thing that we did talk about that you mentioned was under the APA, in particular, the cost benefit analysis. And there's just one thing I wanted to note. I noticed it, and for those paying attention, this is on page 349. But the SEC comes out and says that in many cases, however, we are unable to reliably quantify these potential benefits and costs. For example, existing empirical evidence does not allow us to reliably estimate how enhancements in climate-related disclosure affect the rule, information processing by investors or firm monitoring. Troy, the other thing that I noticed is preliminary estimates showed that the costs of this rule are in the billions, and yes, that's with a B. How does the SEC justify such an expensive rule, should we say costly rule, when it has a hard time quantifying the benefits and the costs as part of the Administrative Procedures Act?
So again, without going too much into the details around the APA and the admin law aspects of this, but just taking a bit of a step back, look, you point out what one of the criticisms is sure to be, which is to say that the benefits don't outweigh the cost, or you haven't demonstrated because you yourself, regulator, haven't been able to figure it out yourself as to whether or not the benefits outweigh the cost. That's just a paraphrase of the point that you were making, and that point is undoubtedly going to be made. The other side of that coin, so to speak, would be exactly what you saw from the commission, which is to say we can't quantify everything, but we can at least identify the nature of the cost and the nature of the benefits, and try to get, if not some quantitative order of magnitude, perhaps a qualitative order of magnitude, and accordingly make a judgment. So this is a bit of the back and forth around the cost benefit analysis. It's not unique to this case. The question of quantification, needed or not needed, what do you do if you can't quantify, is something that's come up in the context of cost benefit analysis for a long time. Now there's another aspect to it, which in some sense goes to a lot of the substance of the rulemaking. And I do think this is an important point. And that is to say, there is, I believe, widespread recognition that climate risk is a risk, just climate risk as such is a risk, as well as a recognition that there are instances where that risk is material to the financial and operating performance of companies. That's different than saying that climate risk and all climate risk is always material to the financial and operational performance of companies. Those are two slightly different propositions. And then the next step in this is okay, to the extent something is going to be done by way of a regulatory response, who's the right agency given its respective mission? And even when you identify the right agency or agencies, well, what is going to be done? And I think, again, coming back to folks listening and others, not just thinking about the authority question as people will, and the cost benefit analysis as people will, but thinking about, all right, to the extent the SEC is going to go forward, I think there's no doubt that the SEC is going to go forward. What do folks think about the particulars of the rulemaking, and do they see opportunities to make it better, whatever better means from their particular vantage point, which then gets into a lot of the particulars around what the commission's proposed.
Right. And I know you mentioned materiality, and believe me, that could be an event in and of itself. In fact, not to plug us, but it was an event that we had back in October 28th, dealing specifically with materiality. Those that want to go back and look at it, it obviously is important here. And to the extent that it becomes relevant in our continued conversation, I do want to bring it up, but I feel like there's a ton with the rule itself that I do want to get to. And so I want to pop ahead a little bit. We've mentioned TCFD and the GHG protocol. And for those that don't know, TCFD was created in 2015 as a framework to disclose climate-related risks. And GHG protocol, created back in '97, was created to calculate GHG emissions. So that's the framework, or I think is former Chair Clayton has said the framework that they're placing on top of the existing framework that is currently being used. So with those two things in mind, and starting with the premise, Troy, that many companies use TCFD. In fact, I think BlackRock, one of the largest institutional investors, year or so ago, maybe it's last year, required or strongly suggested companies use TCFD. And GHG protocol has also been used by a number of currently been a number of used by companies. So the SEC has said, as a result of that, putting that as part of the rule or making that requirement is not that big of a deal, or it won't be that big of a problem. However, what I've read and heard from people is that most companies that use TCFD or the GHG protocol were not using it in its entirety. They were using it in their own, to talk about materiality, in their own materiality analysis, and then they used what fit for their own individual good. Do you see a problem with using these fairly broad-based principles, especially TCFD, which in fact was used to produce or to disclose information, not to shareholders, but to a very broad group of stakeholders? Do you see a problem with using the standard and disclosure framework in this context?
I think the question in response in some sense is whether or not it's a problem depends on how you're using it. One of the things that the commission went to the effort to state, I think, if I recall correctly in the release, is that they kind of grounded, and that may be the word they in fact use, kind of grounded what they did in TCFD and the GHG protocols because there was experience with it, and they made the claim that because of that experience, there was familiarity by users of the information, but there was also greater familiarity by those who were already preparing disclosures to some degree or another in accordance with TCFD and the GHG protocol. So that's the case for, if you will. A response to that, to your point, would be to say, well, wait a minute. Fair enough that you're grounding those in the disclosures and things people may have familiarity with, but those things weren't necessarily developed with an eye on what the SEC's traditional mission, as it's been understood, is focused on, and so you may have a bit of a disconnect. I think that's why the commission didn't simply say we are only doing TCFD and the GHG protocol, but they seem to look to those as being informative and instructive. And then they would, incorporate as they saw appropriate, but still it's the SEC's rule at the end of the day. So there's a little bit of nuance around it. But I think your point drives as a practical matter to a really important observation, which is to say, even for those companies that have familiarity with TCFD and or the GHG protocols, two important, very practical things. One, have you been disclosing everything? Have you been in both of those, or have you been selective based on your judgment as to what was material? So I think asking the question, all right, even if we're familiar, how is what we have been disclosed? How does that measure up to what this proposal actually would require us to disclose? What's the delta there, and what would we have to do in order to meet this proposal if it went final as compared to what we've been doing historically? I think it's an important exercise for folks to undertake, quite frankly, sooner rather than later. And then secondly, to tease out an aspect of that, it's important to also just take note of the fact that choosing to disclose aspects from TCFD and the GHG protocols is different than being required by your regulator to disclose those things in a document that is going to be filed with that regulator. That's a different posture. Now, I think the commission would say exactly it's a different posture, which is why we're requiring it. But I think for companies to realize whatever their practice in terms of disclosure may have been in the past, this is different. This is sweeping, and it's intended to be sweeping from the commission's perspective, and thinking through sooner rather than later, what would we have to do to comply, not just by way of what would our disclosures look like, but what would we have to do in terms of data collection, in terms of ensuring the data are accurate, in terms of identifying where we have gaps in the data and how we're going to fill those gaps, in terms of figuring out the methodologies for coming up with some of these numbers that you'd be required to disclose, scope 3, for example, the assumptions that you'd be making or not making, having the processes in place, the disclosure controls in place, the governance around all of it, right? Thinking that through sooner rather than later, I would say is a very important step. Now, it may feed into whether or not you engage with the regulator, it may feed into a comment letter, but if nothing else, even if it doesn't do that, it will certainly give companies a bit of a head start. I don't know where the final rule is going to land, but it's going to land somewhere. And I think that exercise sooner rather than later would be constructive and helpful for companies.
Well, and we'll talk about scope 3 in just a minute, because there is a lot of concern and questions and on both sides, both for and against, some very strong opinions based on that. But it seems like though throughout, the SEC is very consistent, with no pun intended, in their request for a requirement of consistency, of completeness, of comparability. That seems to be the theme throughout all of this disclosure, is that it needs to require these and the specificity in which it does, so that it is comparable. So, and we can talk about in a minute about whether that's a good or a bad thing, but the SEC is very consistent, I think, in why they are requesting the particular information that they are. I do know that some companies have responded by saying that climate issues are dynamic by definition, and as a result of it, how and what we should disclose under either the framework or through the the standards of the protocol vary and depend on the business line and other factors. So unfortunately, like so much in this, it's not a clear answer. I did want to follow up though on something you said, and this is again a part of the rule, and it's under the governance section, and it's I think under 1501 for those paying attention, which is that the issuer, registrant, or company, I just say company because it's easier, that the company that the company's board discloses the specific oversight that they have regarding climate-related risks, and the management's specific role in assessing those risk. And that includes, which I was a little bit surprised about, that includes collectively analyzing data, staffing the issues, ensuring that they have the expertise, create goals and targets, and evaluate their progress. Companies do this on a pretty regular basis internally. Troy, is this new to be requiring this in this specificity for this particular topic, or am I missing something?
No, certainly for this particular topic, to be getting into those more granular aspects, if you will, of the board's role as well as management's role. But I think it's part and parcel of where the commission is going in the proposal for that matter, which is to say, this is a way of saying, look, you got to make more disclosures about how you, at the most senior levels of the organization, are focusing on climate risk and managing that risk and taking it into account in terms of how it's going to impact the business. And one way to do that is to say, all right, companies, tell us what you do. And that then manifests itself in terms of exactly those disclosure requirements that are being proposed. Now, the other side of that is to say, well, wait a minute, this is getting perhaps a little close to sounding a bit more like it's morphing into something that is more akin to substantive regulation as compared to disclosure regulation. And that itself is an interesting discussion. At what point does disclosure regulation have such a substantive impact that it really is tantamount to substantive regulation? And is that appropriate or inappropriate for an agency that is disclosure based when it comes at least to public companies? But be that as it may, I think this is another one of those areas where I think companies should sit back. I mean, my advice, friendly advice, if you will, would be to sit back and think about these disclosures as well as other disclosures and say, all right, if we were to make these disclosures, what would they be? And is that causing them even at this point to ask themselves, are we doing all that we think we could or should be doing when it comes to this? So to put that even a little more generally, I think one of the outcomes of this, and I do believe it's probably an intended outcome, is for companies, as a result of having to make these disclosures, reassess what it is they would be, evaluate what it is they would be disclosing and whether that causes them to reassess their practices, their governance, their oversight, and the like. And each company will make its own determination. But I do think that's an anticipated dynamic coming out of what otherwise is disclosure, what are going to be its more substantive behavioral impacts.
Well, and to that point, I mean, when you look at the language of itself of the proposed rule, they're talking about evaluating progress. Well, that would mean that in fact progress was being made, which means that if progress wasn't being made, the SEC is certainly expressing interest that there be progress. To your point, I think about substantively pushing or nudging the companies into doing what they overall would hope, I think, and argue that is for the best interest of the investors.
Well, and I think if you got 1501, you may be more on top of all the numbers than I am even, but 1501 in terms of, if you will, the governance related disclosures, right? In this particular context, 1502, if I have my numbers correct, and Tim, you correct me, I won't be upset.
Strategy, business model, and outlook.
Yeah, right. And so 1502 is about what are the climate risk impacts and their particular focus on the negative impacts when it comes to business model, strategy, risk management, and the like. And I would very much encourage folks to, if you don't want to read this section of the release, you can read the rule text, because what's notable here, and this goes to the qualitative disclosures, if you will, the regulation SK disclosures as compared to the regulation SX disclosures, which are focused on the financial reporting. what I think is of note here is the breadth of how they define, when you piece all the defined terms together, climate related risk. So it's climate related risk, which has both physical risk and transition risk. And another thing I would encourage folks to do, I don't think we have time, but just look up the definition of transition risk in the proposal. It's very expansive. So it's physical risk and transition risk. It's acute risk and chronic risk. And it's short-term, medium-term, long-term, but we don't have those time periods defined. And so when you piece all that together, that's a really, seems to me, wide set of disclosures. And then you have another question. And so I don't know exactly what the outer limit is, but that's expansive. Again, particularly when you read transition risk and the breadth of that, say, okay. And then you ask another question, which is, all right, once you wrap your arms around what the breadth of that Reg SK disclosure requirement is, then you ask, well, what does the nature of the disclosure need to be in order to meet the disclosure requirement? That is to say, how detailed do the disclosures need to be? And when you just take the spirit of the proposal as a whole, one of the things I think one walks away with is the expectation is not only that you will be disclosing a whole heck of a lot, including as to your whole value chain. That's another aspect of the Reg SK disclosure. It's about impacts on the value chain as well. But that you will be disclosing in a quite detailed and particular way. And so the Reg SK stuff is very sweeping, and that's of course in addition to the financial statement, the Reg SX stuff, which is also I think something important for folks to focus on and start thinking about what those Reg SX financial statement disclosures would be, and then what would be required in order to meet those obligations if this were to go final.
And I'll follow up on that point, but I do want to remind people again to, if you're watching, submit questions using live chat or YouTube or Facebook, or on Twitter using hashtag BPC Live. In just a couple minutes, I'll start answering some questions. In addition to 1502, which is the one we just described, any climate-related risks, again, I totally would agree with you that is worth a read for anybody. The other is 1503, which is risk management. Again, describes the process. So just so if people are paying attention, 1501 is how a board is specifically handling oversight in the management specific role. 1502 has to do with describing the climate-related risks, and 1503 describes the process in which they use. So the SEC, Troy, is really, they want to know every aspect of the analysis. They want to know how the data is collected. They want to know when the data is collected, how is it analyzed, and they want to know what are the determinations, or what are the factors that led to the determination of its disclosure. In fact, I think they even in one of the line items here, they are requiring, they want to know how a company is determining materiality, which is really interesting. I found really interesting. It's like, well, that is the crux of the question of all of this, that a company would have to explain that is pretty, that they would have to say that they have to require a company to explain it is pretty interesting. So to that, just for that background, again, for people that are following, Troy, I think it's worth mentioning the difference between regulation SX and regulation SQ. The former being dealing with the financial statements, the latter being non-financial. If that, maybe that's oversimplifying it, but if you could just briefly discuss that, just so people when they're looking at that, they kind of they understand the difference.
Yeah, I'm not sure I can add much to what you said. SX focuses on financials. SK focuses on the narrative disclosures, and both for sure are important. What I would underscore or emphasize that we said a minute ago is not only folks looking at the portion of the release that goes to SK, in particular 1502, but others as well, but also you release spending time with the portion of the release that goes to the financial statements. And there's a lot in here about the financial statements. And that's worth not overlooking for sure. And again, this common theme of thinking about how to get oneself prepared for how you would comply with these disclosures, right? This is a proposal, so I don't want to jump to this is the final rule. But I guess to come back to something, Tim, you said earlier, the fact of the matter is once a rule goes final, compliance, deadlines are on you sooner than you think. And even a rough cut that companies conduct, even if only for their own internal purposes, about how they would do these disclosures and do they have the information to make these disclosures, is, I think, a sooner rather than later exercise, particularly to the extent an outgrowth of that is there are opportunities for the commission based on input to actually come up with a better rule than what they've proposed. And that input about what it would actually take to get from here to compliance, I think is an important exercise, and perhaps top of mind thinking about that is, as you made reference to, is scope 3. And one of the things that I think is of note throughout the release, there are many instances the commission was reluctant to say, you shall use this methodology or you shall use that methodology, right? They grounded much of this in TCFD and the GHG protocols, as we talked about a little bit ago. But they were otherwise hesitant to say you shall calculate something this way or that way or the other way. So in that respect, they left companies some measure of discretion in terms of methodologies and assumptions, and perhaps in some instances even the data that they draw from. But even in those instances, Tim, you made some reference to this. What the commission also says is, but you have to explain yourself. You have to explain how with the methodology. You have to explain the assumptions. You have to explain the data. You have to explain the gaps in the data. How you feel it. And so it's interesting as I've kind of noodled that one through. I would imagine that companies will like some measure of discretion. On the other hand, now as you not only disclose the outcome of your analysis, but you disclose the methodologies and the assumptions and the data, those are more things you need to make sure you disclose accurately. Now, even that gets a little more nuanced because there are existing bodies of jurisprudence that have some bearing on important aspects of this. There's a whole jurisprudence under the federal securities laws long established around so-called reasons, opinions, and beliefs, with the Supreme Court decision from a few years ago, fleshing that out a bit, the Omnicare decision. So even thinking about, all right, how does Omnicare and the jurisprudence around reasons, opinions, and beliefs have a bearing on disclosures around methodologies and assumptions and the data you used or didn't use? So the more you get into this, in some sense, Tim, it comes back to your question with the comment period, the more you get into this proposal and the release, there are just many, many, many more layers and points of intersection that warrant thinking through to really understand what this proposal would mean if it were to go final in this form or something like it in very practical terms.
Well, I know we are running short of time, and Troy, I knew it was going to happen. There's just so much to cover, but there's no way that you and I can have a conversation and not talk about what is 1504, which is the GHG emissions metrics and disclosure. The rule requires calculation of emissions. I think it's described at 1504D for GHG intensity and 1504E regarding methodology. So I won't go into that because that's a whole literally another hour at least to talk about. However, most of the attention with regards to the metrics is on these things called scopes, and we've talked about scope 3 quite a bit. It is an issue that is on everybody's mind. And just so people know, scope 1 emissions are direct emissions from operations that are owned or controlled by a company. So kind of think of what your business controls internally. Scope 2, if you think about it very simplistically, it's the power that the emissions from the power that you acquire. Think of you're getting power from the power company and what the power company the emissions that they are required to produce that electricity. Then there's scope 3. Some people refer still, this is also indirect, but some people have called these value chain emissions, which I thought was pretty clever. And these have to do with, well, what's not 1 and 2, but they specifically are dealing with what are called upstream or downstream. That is, if you make a widget, what is the raw material? What are the emissions of that which occurred to get you the raw material so that you could make the widget? So that's the upstream. And then the downstream is the final product if you're making a piece of the widget, let's say, and then its use on down. The biggest concern that well, 2 things. The biggest concern people have is it's very difficult to calculate, to get that information, because you're talking about third parties. You're relying on third parties to give you the information, because by definition, you don't control it, is one. On the other hand, most people in this space that are talking about emissions say that scope 3 are the most important, that from the collection of scope data, of emissions data, scope 3 is the most important. So there's been a lot of back and forth about this. Troy, I know that there's some other things that occur of this rule. For instance, on 1 and 2, scopes 1 and 2, you have to have an attestation. Essentially, it's a certification that it's accurate. I don't want to spend too much time on that. It's in there at 1505 if people want to look. Scope 3, though, why is this so difficult? And can the SEC get to a point where companies are going to be able to reliably produce this information? Sorry, and I did spit out a lot there.
No, it's okay. Scope 3, I think, is so difficult because you don't control the information. You don't have the information. You don't own. It's not your information in some sense, right? You're dependent upon so many other data sources in order to make a determination through whatever you consider to be the appropriate methodology and assumptions as to what your scope 3 is. And so anytime you're dependent upon information that somebody else has, that just is inherently difficult as a practical matter. Set aside methodological questions and set aside other assumptions, just the sheer exercise of getting the data. And then what do you do when you don't have the data? No small feat. When you think about that up and down your entire value chain, right? That's, the outer limit of that is pretty far out there in terms of what it is that you need to go track down by way of information. So it's a very practical challenge. Now, what I will say is the following, and I think this is worth noting. The commission recognizes that challenge in the proposal. The commission says in several places, not just in one place, but in several places, it recognizes that it is a challenge. And that companies may struggle. Some may struggle more, some may struggle less, but that companies may struggle for these very reasons. And in fact, they specifically call out gaps in data and then say, you got to figure out what you're going to do if you have a gap in your data, and you're going to disclose what you did if you have a gap in the data, so that users of your disclosures can evaluate your disclosure in light of not only your methodology and your assumptions, but any gaps in the data and how you fill those gaps. So there is an express recognition by the commission of the challenge. Nonetheless, they decided to move forward. But what they did do is 2 things that they explain in the proposal. One is they didn't say that all companies need to make scope 3, right? There's a carve out for smaller reporting companies. And even for large accelerated and accelerated, what they said is you need to make the scope 3 disclosures if you decide they are material, or you have a GHG target that you are striving for. Now, on that, what a lot of folks have suggested and paused on is, what are the circumstances under which a company may be comfortable making a determination that their scope 3 is not material, particularly in light of all of the things the commission says in the release about why they think scope 3 is important. And Tim, to your point, that a lot of people have said scope 3 is important. So even though you only have to make the scope 3 disclosure if you decide it's material, how much comfort is there going to be saying not material, and therefore I don't need to make the disclosures? That's one point that has come up. But what the commission also did, I think, recognizing the challenges associated with scope 3, is they provided a safe harbor. And they said, look, your scope 3 disclosures won't be considered fraudulent statements. And they have a defined term, which is kind of pulling together the various words and phrases from various anti-fraud provisions under the federal securities laws, all into this new definition, fraudulent statement. Frankly, one of the exercises is to go through and make sure that it covers all the quote unquote magic words it needs to cover from all the anti-fraud provisions. But I think that was the intent. But any misstatement, if you will, in your scope 3 disclosures would be considered a non-fraudulent statement if you had a reasonable basis and you otherwise made those disclosures in good faith. They may state it a little bit differently, but that's basically what it boils down to. So I think that's a further nod in the direction of the challenge of coming up with scope 3 and the attendant liability therefore associated with it. So hence the safe harbor. One of the things I think is important is to really think through, and I'm frankly still thinking through, what does the safe harbor really do in practice? And that is to say, if you flip it around, I think this is the case, although I may be wrong. Again, I'm very much still digesting all of this, would be to say, well, if you have a reasonable basis for your statement and you made it in good faith, you didn't commit fraud. Well, it may be that if you did that, you didn't commit fraud in any event. So I'm not sure. There's probably something in the Venn diagram that I'm missing at this point, but I will just confess it's not jumping off the page to me what the practical effect is of this safe harbor, given how it's fashioned and what the anti-fraud provisions by way of the elements of those offenses already require, particularly when it comes, for example, to 10b, 10b-5, where negligence itself wouldn't be a violation. So acting non-negligently should certainly already not be a violation, in which case does the safe harbor do anything under 10b, 10b-5 of the anti-fraud provision? So it's
other than just make people feel a little bit better.
Well, and it's a good illustration to my mind of the importance of just continuing to put it very simply, kind of crunch through the proposal and really kind of stop and pause on almost every word and say, okay, what does this really mean? What does it really mean? How's this really going to work? Do I really know what it means? Should there be more clarity, less clarity? What would I do in response? Is there another way? There's just no substitute for that sort of crunching through. And I think the safe harbor, for me, is a good example where it sounds promising, but when you crunch through it, you at least, or I should say, I at least pause and wonder how much oomph is there to it. And if there's not much oomph, what could change to give it more oomph, precisely because of the concerns that the commission itself appropriately recognized on the challenges regarding scope 3.
Right. Well, I know that we didn't leave too much time here, unfortunately, for some questions, but I do have a couple. Wanted to throw them out at you. One, it just came in as there are about 20 different international groups coming up with what to track and measure for materiality. Is the SEC working with, say, EU groups? And I know we didn't specifically touch on materiality, but I suspect that the discussion of double materiality is probably in the response to that answer.
Yeah, I'm going to be real quick, just with the eye on the clock, so to speak. Regulators around the globe have lots of different opportunities to engage, interact. IOSCO is one of those more formal settings, but it can occur in less formal ways, if you will. Plus, of course, you see and observe, you read, you learn from ideas around the globe, right? Not just around the U.S., but around the globe. So there's no doubt in my mind that folks at the SEC are well aware and well versed in the different approaches to materiality around the globe. And I would just note here that one of the things that is important to observe when it comes to materiality is that the commission places a great deal of emphasis in the proposal on the amount of AUM, which from their perspective is requesting this information. I'll just kind of throw out there, that's an interesting way of approaching materiality. And there's, I think, a lot to be unpacked about how the SEC approached materiality in this proposal and how that aligns with what some people view as the approach reflected in the jurisprudence over the decades.
Yeah, or maybe even more simply put, it bases this rule on investors' interests, but the question then becomes which investors? Are we talking institutional investors? Are we talking activist investors? Are we talking retail investors? All of which probably could theoretically have different opinions as to this. In fact, some of the studies show just that.
Well, and it is an important observation too, which is different investors want and demand different things, right? There will no doubt be investors who are very supportive of this proposal. There will no doubt be investors who are, let's just say, less supportive of this proposal, or at least less supportive of aspects of this proposal. And so to the extent one roots the proposal in what investors want, it does, Tim, to your point, raise the question, well, what if investors want yes and no on this? Then how does that factor into the overall, at the end of the day, judgment?
Well, and just lastly, I wanted to get this one in because it's very relevant, I think, to the last point, which is the question if the presuming, and then the question does that the SEC is moving forward with these rules to influence or to support divestiture from carbon intensive companies. So that with that presumption, the question is, if it doesn't happen, if this rule goes through and that doesn't happen, will there be more rules? Will there be more rules to try to get to that goal? I have some opinions on that, Troy. I don't know if you are. It obviously is a presumption that the SEC is, I don't think, willing to publicly make that that's what it is, even though that may appear to be the case. I think it will depend. However, if the basis of this rule is in fact on the investors that have submitted comments to the SEC and sat down and talked with the SEC, sure, I think it's possible that there will be more rules. For instance, one of the issues about this rule is there's the attestation or the certification, as we talked about, is only for scope 1 and 2. I know that, for instance, Commissioner Allison Lee is a proponent of having that attestation for scope 3 as well. So I think that there's plenty of room for this rule, either this particular rule or future rules to continue on disclosure. Troy, I don't know what your thoughts are.
I would just end with this. I think that it's important, coming back to the context that you laid out at the start, Tim, to situate what the SEC's proposal and presumably final rulemaking at some point within the broader landscape. And that is to say, there's other parts of government that are focused on this from different vantage points, financial regulators, but non-financial regulators, the EPA, for example. But it's not just the federal government, states as well. And it's not just the government. I think another really important dynamic is there are shifts in terms of market expectations of one type or another. There are different stakeholders demanding different information for one reason or another. So from a company's perspective, it strikes me, yes, this rulemaking, I think, is extraordinarily consequential. But it's not just this rulemaking, and it's not just regulation. It's also thinking about how you're going to be responsive to your broad set of stakeholders and the choices you're going to make from that perspective. Which, to end on maybe just one other quick note, is I personally think it is important to recognize and to acknowledge the amount of progress that businesses have already made on this front. That this rulemaking takes place against what is a dramatic increase in climate-related disclosures that companies, fair enough, facing interest and pressure from various stakeholders, but that companies have chosen to disclose, and that actually is exactly what "quote unquote" market discipline and private ordering would predict, and we've seen that, and I think that's again an important backdrop that's worth taking some note of.
Well, Troy, thank you so much again. Appreciate your time this afternoon and getting through a pretty technical rule. There's a lot there, as you say. There's over 500 pages, and it's a lot there. But it's definitely worth a read for anyone that's truly interested in this. You can actually just go and read the sections that specifically just lay out what it is that the proposed rule is, as opposed to the commentary, and you'll still get a really good idea of what the rule is about. So again, appreciate, Troy, you coming on, and for those that have been following BPC, thank you. Appreciate your support and following This is an ongoing series, as you guys well know, on corporate governance and ESG. And in fact, in this particular topic, we may well have another event. So appreciate, again, your support and look forward to seeing you next time.
Thanks, everyone.